Good afternoon, ladies and gentlemen. A while back, we had discussed the Philippine Constitution. We had started discussing Philippine Constitution, and we were able to finish the Bill of Rights, in which I failed to mention under Article 3 the examples of protection of life. So we protect the Philippine National Police should protect life from harm. Okay, so from death without due process. Sabi niya doon kanina is even the unborn children. So, killing of an unborn child would be an abortion. Okay? So, an abortion. Killing of a baby less than 3 days old is infanticide. Yan. Killing of a direct descendant or ascendant is parricide. And of course, homicide and murder. Yan. So, yan po yung mga pagpatay. Yan. So, in violation of the protection of life. Yan. So, in relation to the protection of properties, nasabi ulit natin, property crimes po yung mga yan, di ba? Such as malicious mischief, arson, theft, robbery. So, ano naman yung protection against liberty? So, yan yung abduction, illegal detention, kidnapping, arbitrary detention. So, yun. So, we will be now proceeding with the discussion on Filipino citizenship under Article 4 of our 1987 Philippine Constitution. So, the following are citizens of the Philippines. Those who are citizens of the Philippines at the time of the adoption of the Constitution. So, 1987 Constitution. Those whose fathers or mothers are citizens of the Philippines. So, pagka Filipino citizen na tatay mo, automatic, Filipino citizen ka. Those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. So, hindi na niya sinabi kung foreigner ang tatay mo. So long as you have a Filipina mother before January 17, 1973, you are considered Filipino. Those who are naturalized in accordance with law. So we have this naturalized Filipino to which a foreigner can convert citizenship into a Filipino. However, when it comes to the PNP requirements, ladies and gentlemen, naturalized Filipino are not allowed, not qualified to apply in the PNP. Same is true in the security profession, private security profession. So, bawal din ang naturalized Filipino doon. Next, Section 2. Natural-born citizens are those who are citizens of the Philippines from birth without having to perform any to acquire or perform their Philippine citizenship. Those who elect Philippine citizenship in accordance with paragraph 3, section 1 hereof shall be deemed natural-born citizens. So kung tayo, parents natin, both Filipino, dito pa tayo sa Pilipinas pinanganak, we are called natural-born citizens. Natural-born Filipino. Section 3, Philippine citizenship may be lost or reacquired in the manner provided by law. Okay, so we can lose and we can reacquire our Filipino citizenship. So, citizenship of the Philippines who marry aliens shall retain their citizenship unless by their act or omission they are deemed under the law to have renounced it. So pagka ni-renounce nila pagka Filipino citizenship nila, after they have married an alien or foreigner, then they may lose their Filipino citizenship. Section 5. Dual allegiance of citizens is inimical to the national interest and shall be dealt with by law. So, when you say dual allegiance, dalawa ang allegiance mo. You serve or you give informations, vital informations to foreign country about the weakness and strength of the Filipinos and the Philippine, baka malusob na tayo ng bansa na kung nagbibigyan mo ng vital information, di ba? Thereby, it shall be dealt with accordingly. Dual allegiance is different from dual citizenship, ladies and gentlemen. When we say dual citizenship, a person may be Filipino citizen and at the same time a citizen of the other country to where he or she uh, had yan, flight, float. Yan. So, saan man siya napunta, nagtungo? Ano ba yung tamang term doon? To where she had went abroad. So, Article 5 is about our right to suffrage. Hindi yan right to suffer, right to suffrage. Our right to vote. Suffrage may be exercised by all citizens of the Philippines not otherwise disqualified by law, not disqualified by law, who are at least 18 years of age and who shall have resided in the Philippines for at least 1 year and in the place wherein they propose to vote for at least 6 months immediately preceding the election. 6 months before the election. No literacy, property, or other substantive requirement shall be imposed on the exercise of suffrage, on our right to vote. So, means to say, wala tayong babayaran sa pagboto. Okay? Walang property involved. Walang prerequisite, substantive prerequisite. Means to say, substantive, yung parang may kailangan ka pang gawin. Sabi niya 18. But for SK chairman, those with age 15 to 30 are allowed to vote for SK chairmans. Okay, SK chairman. Now, 18 and above will vote for the positions of kagawad for the barangay and SK elections, BSK election, to the national elections. Ayan. So, from barangay election, yung kagawad to national election, presidency. Yan. Yan yung mga may edad na 18 above. Yan. But for the position of SK chairman, the age again is, yung mga age ng boboto is age 15 to 30. Yan. 15 to 30. So, Section 2, the Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as a system for absentee voting by qualified Filipinos abroad. Yan. So, pwede rin yan. The Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as a system for absentee voting by qualified Filipinos abroad. Pwede ring magboto yung mga nasa abroad. Okay? Pwede rin yan. Paano? Through absentee voting. Mauna silang mag-abroad. Maunang magboto before the exact date of election. The Congress shall also design a procedure for the disabled and illiterates to vote without the assistance of other persons. Until then, they shall be allowed to vote under existing laws and such rules as the Commission on Election may promulgate to protect the secrecy of the ballot. So, pwede rin kahit na edukado, hindi nakapag-aral, matanda, hindi makabasa, pwede rin bumoto. And we have here Article 6, Legislative Department. So, when you say legislative, these are the bodies who creates laws. The legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. So that is on legislative department. O wag na nating basahin yung iba. Bakit kung naka-hide? Lumalabas pa rin. We have here other articles of the Philippine Constitution. So, Article 7 is on the Executive Department, di ba? Article 6 is on the Legislative Department. So, ano ulit yung Legislative Department? These are the law-making bodies, yung Congress and Senate. How about the Executive Department? Under Article 7 of the Philippine Constitution, 1987 Philippine Constitution, it refers to the law enforcement agencies. Their highest is the President of the Philippines. We also have here the Judicial Department. So the courts, the Supreme Court, the Prosecutor's Office, the Bucor, or all of those are under the Judicial Department. The PAO, yeah, Public Attorney's Office. We also have the Constitutional Commissions, the local government, per municipality, province, barangays, accountability of public officers, national economy and patrimony, social justice and human rights, Article 13, education, science and technology, arts, culture and sports, Article 14, 15, the family, Article 16, the general provisions, Article 17, amendments or revisions, and Article 18, the transitory provisions. So let us now proceed with the statutory rights of persons subjected to law enforcement operation. Okay, so we were able to discuss the constitutional rights of persons subjected to law enforcement operations. Now we will be discussing the statutory rights of persons subjected to law enforcement operations. So what are the bases or the legal mandates of these statutory rights? They are lifted from our special laws. Yan. So first on the list, the human rights in relation to torture, the Miranda Rights, rights of persons under custodial investigation or RA 7438, and also rights of the accused. So let's start with human rights. Human rights are rights inherent to all human beings regardless of race, and, white, black, kayumangge, sex, male or female, nationality, Filipino, Colombian, Mexicano, ethnicity, culture, yan, ethnic group, language, English, Filipino, religion, Catholic, Muslim, or any other status. So, human rights. Okay? Human rights are inherent regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life, yan, as provided for by our Philippine Constitution. Right to life, right to liberty, or freedom from slavery and torture, freedom of opinion and expression, freedom of speech, the right to work and education, especially the right of children, the right to education, and many more. So those are just an example of our human rights. Our human rights composed of very broad rights. The concept and practice of human rights within the Philippines is defined by Article 3 of the Philippine Constitution. Again, that's the Bill of Rights, as well as the United Nations International Bill of Human Rights, to which the Philippines is a signatory. It is a member. So we have here human rights as defined by Republic Act number 10368. 10368, RA 10368, is an act providing for the reparation and recognition of human rights violations during the Marcos regime, documentation of the said violations, appropriating funds therefore, and for other purposes. Next is the Miranda Rights. It states that you have the right to remain silent. Any statement you make or do or say may be used against you in the court of law in the Philippines. You have the right to an independent and competent counsel, preferably of your own choice, and if you cannot afford the service of a private counsel, the government will provide one for you. And of course, ladies and gentlemen, we should make sure that the arrested person, should be able to understand these Miranda rights, which was just read or mentioned to him. Thus, we have to ask him if he had understood his rights. We base this from the U.S. case of Miranda versus State of Arizona, where the U.S. Federal Supreme Court acquitted an accused because he was not properly advised of his rights before he made a confession. So he made a confession, but the problem is he was not informed of his rights. Okay. So in short, any violation of this Miranda right would lead to the technicality of the case. Thereby, even if we are sure that the accused is actually the person who perpetrated the crime, but due to our technicality, due to the failure of the investigator or the police officer to state the Miranda rights of the accused, it can result to the dismissal of the case or to the acquittal of the accused. Sayang ang kaso. Baka marami pang mabiktima yan, di ba? Yung perpetrator. In the Philippines, the right to counsel espoused in Miranda Doctrine was based on the leading case of People versus Galit and Morales Jr. versus Enrile, a ruling subsequently incorporated into the present Constitution. The Miranda Doctrine under the 1987 Charter took on a modified form where the right to counsel was specifically qualified to mean competent and independent counsel, preferably of the suspect's own choice. Therefore, ladies and gentlemen, if it's the PNP who give the accused his lawyer, do you think that is uh, an independent counsel in the choice of the suspect or the accused? Hindi, di ba? Hindi. So, that scenario would lead to the acquittal or possibly the dismissal of the case. Okay? So, the counsel shall be preferably independent and competent on the choice of, or the personal choice of the suspect or accused. Again, I repeat, waiver of right to counsel likewise provided for stricter requirements. Compared to its American counterpart, it must be done in writing and in the presence of counsel. Okay? So, waiver of the Miranda Rights can only be done in writing and in the presence of the counsel. So, if there's no counsel or if there's no written uh, waiver, then such waiver is void, null and void. Okay? We have here the rights of persons under custodial investigation as provided for by RA 7438, an act defining certain rights of persons arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violations thereof. Be it enacted by the Senate and House of Representatives of the Philippines in the Congress assembled the following. Section 1, Statement of the Policy. It is the policy of the Senate to value the dignity of every human being and guarantee full respect for human rights. Okay? So if you come to check all of these rights, your constitutional rights, your rights of persons under custodial investigation, your Miranda rights, your human rights, these are all overlapping, entangled with one another. Okay? So rights of persons arrested, detained, or under custodial investigation, and the duties of public officers. Any person arrested, detained, or under custodial investigation shall at all times be assisted by a counsel. Okay? So, he shall be assisted by his independent and competent counsel of his own choice up to the end of his nakakatakot naman kung sabihin natin up to the end of his life yan. So, up to the end of, up to the termination of his case. Any public officer or employee or anyone acting under his order or his place who arrests, detains, or investigate any person for the commission of an offense shall inform the latter in the language known to and understood by him of his right to remain silent and his right to have competent and independent counsel, preferably of his own choice. So what right are these? This is referring to the Miranda rights, who shall at all times be allowed to confer privately with the person arrested. Okay? So the private and competent lawyer should be allowed to confer privately with the with his client. If such person cannot afford the service of his own counsel, he must be provided with a competent and independent counsel by the investigating officer, and it will be coming from the PAO, the Public Attorney's Office. The custodial investigation report shall be reduced in writing, okay? It must be done in writing by the investigating officer provided that there or that before such report is signed or thumb marked, if the person arrested or detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or by assisting counsel provided by the investigating officer in the language or dialect known to such arrested or detained person. Otherwise, such information report shall be null and void and of no effect, okay, of no effect whatsoever. Any extrajudicial confession, so when we say extrajudicial confession, this is a confession conducted in two or more different uh, two or more different places. It is an it is a confession done outside of the courtroom. So yan, so yun yung best definition niya. Any extrajudicial confession made by the person arrested, detained, or under custodial investigation shall be in writing and must be signed by such person in the presence of his counsel or in the latter's absence. Upon a valid waiver and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, the district school supervisor, the priest or minister of the gospel as chosen by him. Otherwise, extrajudicial confession shall be inadmissible as evidence against him in any of the procedure. Next is the any waiver by a person arrested or detained under the provision of Article 125 of the Revised Penal Code or under custodial investigation shall be in writing and uh, and shall be signed by such person in the presence of his counsel. Otherwise, waiver shall be null and void and of no current with no effect. Yes, no effect. Any person arrested or detained or under custodial investigation shall be allowed visits, okay, by or conferences with any member of his immediate family or any member, doctor or priest or religious minister chosen by him. Yan. So it must be chosen by the person itself or by any member of his immediate family or by his counsel or by any national non-governmental organization duly accredited by the Commission on Human Rights or by any international non-governmental organization duly accredited by the Office of the President's fiancé, accredited by the Office of the President, the person's immediate family shall include his or her spouse. Yan. So, kasama dapat yung kanyang spouse, kasama yung kanyang fiancé, parent, or child, brother, sister, grandparent, or grandchild, uncle or aunt, nephew, or yan, niece, and guardian, or ward. As used in this act, custodial investigation shall include practice of issuing an invitation, okay, to a person who is investigated in connection with an offense he is suspected to have committed without prejudice to the liability of the inviting officer for any violation of law. The assisting counsel, other than the government lawyers, shall be entitled to the following fees. So, merong fees. The amount of 150 pesos if the suspected person is chargeable with light felonies. So, pagka light felonies, ang kaso niya, 150. The amount of 250 pesos if the suspected person is chargeable with less than or with less grave or grave felonies. The amount of 350 pesos if the suspected person is chargeable with a capital offense. Yan. 150, 250, to 350. So, Republic Act number 857, as amended, is hereby repealed. Other laws, presidential decrees, directive orders, or rules and regulations, or parts thereof, inconsistent with provisions of this Act, are repealed or modified. Mhm. Modified accordingly. And Section 6, this Act shall take effect 15 days following its publication in the official gazette or in any daily newspapers of general circulation in the Philippines. So with that, ladies and gentlemen, time check, it's already 4:41. So do you have questions so far? Mhm. Ano pala? Any person arrested or detained under custodial investigation shall be allowed visits by or conferences with any family member. So, tandaan nyo yan, ha. As used in this act, custodial investigation shall include the practice of issuing an invitation to a person who is suspected to have committed without prior judicial to the liability of the inviting officer or for any violation of the law. Okay? So the mere we had invited a person for investigation, it is already counted as a staffa. Hindi pala staffa yun. Property crime pala yun. The assisting counsel is other than the government lawyers, which shall be entitled to the following fees. Nawasan na natin yun kanina. Naulit ko lang, ha. 150, 250, and 350. So, Section 5, repealing clause. RA number 857 as amended is hereby repealed. Other laws, presidential decrees, executive orders, or rules and regulations are parts hereof. Inconsistent with the provisions of this act are repealed or modified accordingly. So section 6 is on the effectivity. This act shall take effect 15 days following its publication in the official gazette or in any daily newspaper of general circulation in the Philippines, as approved on April 27, 2023. So we also have here the rights of the accused at trial. When an accused under custody escapes, he shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person while it sufficiently appears to the court that he can properly protect his rights even without the assistance of the counsel. So it is also the right of the accused to testify as witness in his own behalf, but subject to cross-examination matters covered. His silence shall not in any manner prejudice him, and to be exempt from being compelled to be a witness against himself. Why? Because if he became a witness of himself, it is ang tawag, to exempt from being compelled to be a witness against himself, the right against self-incrimination, and to confront and cross-examine the witness against him at the trial. So that's the task of our prosecutor or our defense counsel. Either party may utilize as part of his evidence the testimony of a witness who is deceased out of the testimony of a witness out of yan, deceased or out of persons who cannot vote due to diligence but they were found in the Philippines, unavailable or otherwise unable to testify given in another case or proceeding, judicial to administrative involving the same parties and subject matter. So the adverse party having the opportunity to cross-examine him or her. So, post na muna tayo dito. So, let's resume, ladies and gentlemen. So, let's continue to discuss rights of the accused at trial. So, the accused has the right to confront and cross-examine the witness or witnesses against him at trial. Either party may utilize as part of its evidence the testimony of a witness who is deceased out of or cannot with due diligence to be found in the Philippines, unavailable or otherwise unable to testify. Given in another case or proceeding, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. That's why during trial, the uh, the prosecutor will present first his witness. He will examine it. Ang tawag doon, direct examination. Di ba? The prosecutor will question, di ba? Will ask a question to the victim or to the accused. Tapos, after to the victim, hindi pala accused, to the victim. And the victim will answer it. After that, the defense counsel, the counsel of the accused, or the accused through his counsel, will ask a question to the victim or complainant. Ang tawag naman doon, cross-examination. So yan yung cross-examination in relation to the previous testimony of the complainant. Now, if let's say for example, if the defense was able to establish a doubt during his cross-examination, then the prosecutor should fix o kaya should eliminate the doubt through a redirect examination. Again, yan. So, redirect examination ulit. Then, what follows next is, after the redirect examination by the prosecutor to the complainant, the accused, through his counsel, will again conduct a cross-examination. So, ganyan. So, direct examination, cross-examination, tapos redirect examination, and recross examination. The accused has the right to have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. Yan. So, magpapas-subpoena rin ang court to the agencies or persons to testify or to produce the evidence needed by the accused. So, may kailangan si accused na ebidensya from let's say for example, from a private individual, then the court will issue a subpoena towards address to that private individual, requiring that private individual to bring the evidence. Yan. Kasi meron tayong tatlong uri ng subpoena, di ba? Subpoena ducis tecum requires a person to produce document or evidence. Subpoena ad testificandum, it requires a person to appear before a court and testify during trial. Tapos we have the combination of these two. We have the subpoena ducis tecum ad testificandum, requiring a person to appear before trial and to bring with him necessary pieces of document or evidence and testify in relation thereto. Yan. Next, the right of the accused to have speedy, impartial, and public trial. So, pwedeng i-demand nung accused yan pagka nakikita nila na tinatantan, dinidelay ng prosecution, ang kaso, the accused can demand for speedy trial and impartial, of course. And it must be done in public. So, public trial. To appeal in cases allowed and in the manner prescribed by law. So, pwede rin silang mag-appeal. It's a right of the accused. So, kung natalo yung accused sa kaso niya sa MTC, pwede siyang mag-appeal to the next higher rank and next higher court RTC. Next to RTC, pwedeng sa Court of Appeals hanggang sa Supreme Court. Yan. So, it's the highest court of the land. By the way, we also have to review this Executive Order 272 dated July 25, 1987, amending Article 125 of the Revised Penal Code. It says, Section 1 says, Article 125, delay in the delivery of detained person to proper judicial authorities. So, yun siya sabi natin, arbitrary detention. The investigator or the police officer weren't able to file the case within 12-18-36 hours. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities. Bakit hindi nga na-file yung kaso? Within the 12 hours for crimes or offenses punishable by light penalties, order equivalent, 18 hours for crimes or offenses punishable by correctional penalties, order equivalent, and 36 hours for crimes offenses punishable by afflictive or capital penalties or their equivalent. Now, any violation of this act, the public official, the police officer, or the public officer can be held liable for arbitrary detention. In every case, the person detained shall be informed of the cause of his detention. Okay? So yung arestadong tao ay kailangang ma-inform ng kanyang cause of his detention and shall be allowed upon his request to communicate and confer at any time with his attorney. Sorry. Yan. With his attorney or counsel. So, that's stated for in the Philippine Constitution, tapos na ulit pa sa Miranda Rights. All laws, orders, issuances, rules, and regulations or parts thereof inconsistent with executive order are hereby repealed or modified accordingly. So when we say repealed, yan, na-repealed na. Wala nang bisa yung Article 125 of the RPC. So itong Executive Order 272 na ang nasusunod. Yan ang ibig sabihin yan. This executive order shall take effect 30 days before or 30 days following its publication in the official gazette. Done in the city of Manila this 25th day of July in the year of the Lord 1987. 1987. So with that, ladies and gentlemen, that's all for the constitutional and statutory rights of persons detained in relation to law enforcement operation. So see you next meeting. Thank you very much and let's call it a day.